Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, so this is our last podcast of 2024, but I've got three interesting cases for you. So kicking off with one in which the Court of Appeal held that two directors of a company were not in breach of their fiduciary duties when they had been taking preparatory steps to set up a competing business. So the two directors were directors of a company that was a corporate firm of solicitors, specialising in financial mis-selling and fraud claims. And because they were directors of the company, that meant that they owed certain fiduciary duties to the company. So to act in good faith in the best interests of the company and not place themselves in a position where their own interests conflicted with those of the company. The two directors were also each party to a consultancy agreement under which they provided legal services to the company for 40 hours a week. And those agreements, the consultancy agreements, contained a 12-month restrictive covenant that prevented the directors from soliciting the company's clients with a view to supplying services to them in competition with the company. So the directors resigned as directors on the 10th of January 2023, and at the same time, they gave the required 6 months' notice to terminate their consultancy agreements. After that had happened, the company then discovered that actually, in the 5 months leading up to their resignations, the directors had been taking various steps to set up a new business which would also provide legal services, so the same as the company was doing. So, in particular, the sorts of things that the directors had been doing, they'd registered the trading name of their new firm. They'd incorporated a new company that was going to be the trading vehicle. They'd opened a bank account. They'd applied to the Solicitors Regulation Authority, the SRA, for the regulatory approval that they'd need to operate that new firm. And they'd even entered into discussions with a litigation funder with whom those two directors had previously negotiated on behalf of the company. So the company wasn't very happy about all of that, and it brought proceedings against the two directors, alleging that they were in breach of their fiduciary duties and also the restrictive covenant. So the trial judge found that the directors' preparatory steps had not put them in a position of conflict and that they were not in breach of those restrictive covenants in their consultancy agreements. But the company appealed that decision, and the Court of Appeal, when it looked at it, it said, well, there was no evidence that the directors had solicited the company's clients, so therefore there was no breach of the restrictive covenant in the consultancy agreements. So that was off the table. So the Court of Appeal then focused on whether the directors had breached the fiduciary duties that they owed to the company. And when it was looking at this, the Court of Appeal said, well, each case that involves taking preparatory actions by directors was highly fact sensitive. Just making a decision to set up a competing business at some point in the future wouldn't be a conflict of interest, but clearly soliciting customers or actually carrying on a competing trade, that would be a breach. But in between those kind of two ends of a spectrum, there's a whole wide range of activities in falling into that grey area that would be fact sensitive in each case and would have to be looked at on a case by case basis. So, looking at the particular steps that the directors had taken in this case, the Court of Appeal said, well, the directors didn't intend their new company to trade until after the end of their contractual notice period. So they gave their 6 months notice period and they weren't intending to start trading until the end of that. The directors had not formed an irrevocable intention to compete with the company until late December 2022 or early January 2023. And the intention to compete was not cemented until the SRA had confirmed that it was going to approve the registration of the new vehicle. And that happened on the 6th of January 2023. Remember, the directors then resigned on the 10th of January. And the court said that when they did resign, the plans were still at an early stage. At that point, they'd got no clients, they'd got no funding, no premises, no staff. And then the other point that the company had raised in its arguments related to the fact that the two directors had been having discussions with a litigation funder. And the court said, well, that didn't give rise to a conflict of interest. That was what the company had tried to argue. And the court said, well, that was tenuous at best, because it turned out that actually the company had already entered into an exclusive contract with a different litigation funder. So to argue that the directors now talking to the original funder gave rise to a conflict of interest was not realistic given the company's exclusive arrangement with another funder. And also, actually, there was no evidence that if that exclusive contract with the other funder came to an end, then both the company and the new company formed by the directors could both have dealt with the original funder. There was no problem with that. So the court dismissed the company's appeal. So I thought that was quite an interesting case. It's obviously a useful reminder that whether or not a director is in breach of their fiduciary duties will turn very much on the specific facts of each case. And even if a director's formed an irrevocable intention to establish a competing business, that in itself, even though you could think, well, their mind isn't on the business of the company, they're clearly thinking about doing something else, but just intending to do it doesn't actually give rise to an obligation at that stage to disclose it to the company. But whilst they can take a range of preparatory steps, things like happened in this case, so setting up a company, opening a bank account, applying for authorizations, they must stop short of actually competing, because at that point they will have crossed a line. And where any particular activity sits on that spectrum is going to have to be very carefully considered in each individual case. Okay, so the next case to mention, another interesting one I thought, because this one, the High Court found that an undocumented oral agreement between a father and his son to transfer their shares in a family business to each other on their death overrode the father's earlier will, under which the shares had been left to his wife, the son's mother. And just for simplicity, I'm going to refer to all the people involved in this case by their roles within the family, just to make it easy to understand who's who. So the facts here were that in 2001, a father made a will under which his wife was appointed as the sole executor, and all his assets would pass to his wife on his death. Then, 2 years later, in 2003, the father and son decided to go into business together, setting up a construction company. Now, based on advice that they received from their accountant when they set up the company, the shares in that company were issued 40% to each of the father and the son, and then 10% to each of the wife and the son's wife, the daughter-in-law, if you like. Now, crucially, the son said that when the accountant attended a meeting with all four family members to discuss the formation of the company, it was agreed at that relatively informal meeting that if the father died, his shares would go to the son, and conversely, if the son died, his shares would go to the father. But the wife alleged that no such agreement was reached, and the question of what should happen to the shares on the death of either the father or the son was actually not discussed at that meeting. It was also sort of agreed through the trial process that to the extent that the accountant had suggested at the meeting that the parties should document the arrangements in a shareholders agreement, and there was some dispute about whether or not that had been suggested, but if it had, the family had declined to do that on the basis that they were close and trusted each other. Now, unfortunately, in 2009, the father died. And following that, the accountant filed documents at Companies House which showed that the father's shares had transferred to the son on the date of the father's death. Now, at that point, nothing was said by the wife in relation to the father's shares, either when the father died, when the documents were filed at Companies House, or in the following few years. So later on, 8 years later, in 2017, relations between the parties broke down, and following that, the wife brought proceedings against the son and the company, arguing that the father's shares should have passed to her, to the wife, under the will, in accordance with the relevant provisions in the articles about transmission of shares on death. So, when it came before the court, the judge noted that there wasn't really any written documents related to the arrangements. He actually said there was a dearth of contemporaneous documentation. So instead, he had to rely on the oral evidence of the various witnesses involved. And based on that, the judge was satisfied that there was an oral agreement, and remember, agreements can be reached orally, between the four shareholders, that on the death of either the father or the son, the deceased's shareholding would be transferred to the survivor of those two. There were various factors that the court took into account, reaching that decision. So, for example, the company was a vehicle for the father and the son to carry on business together. And if one of them died, then the other would be the sole means of keeping the business going. Although the wife and the daughter in law had shares, they weren't actually involved in the business at all, and they weren't capable of doing the construction work that the company was engaged on. The court also looked favourably, if you like, on the evidence of the accountant. So remember, the accountant was there. They gave evidence about what had happened at the family meeting and the transfers of shares. And the court said that evidence was important because there was no reason why the accountant would be dishonest about that. At the point at which the transfer of shares was notified to Companies House, relationships within the family were close. And then following the father's death, when the wife was aware of the terms of the will, and even immediately following the breakdown of relations in 2017, the wife had never claimed to have anything other than a 10% shareholding at that stage. So, as I say, in this case, the father's will had effectively been overridden by the oral agreement between the parties. And you might think that seems odd, being able to override provisions in a will in that way. But effectively, it was an agreement that had been entered into by the father, the deceased. And because of that, his executor, the wife, was bound by it because the executors are bound by agreements entered into by the deceased. And so, because the shares had already been registered in the son's name, then actually no action was required to perfect that oral agreement reached between the father and son. But the court said that actually, if the shares had actually passed to the wife in accordance with the will, then the court would have required the wife to transfer the shares to the son in order to give effect to the oral agreement. So, what lessons can we take away from this one? Well, I think probably the most important one is the good old lawyer's mantra of put it in writing. So, if the family had taken the advice of entering into a shareholders agreement and recording the arrangement in writing, then there would have been no dispute as to its existence. So that, as I say, oral agreements, oral contracts are valid, can be enforceable, but the problem that you have with them is evidential. So, can you prove that an oral agreement, an oral understanding was reached, was entered into? So, as I say, in this case, the family declined to do that, saying that they were a very close family, they trusted each other. But I think sadly, all too often, it is those kind of people that suffer from a lack of clear documented arrangements when things unfortunately do go wrong. Okay, Finally, our last case of 2024. So, this one relates to the circumstances in which investors can bring a claim against a company on the basis that they based their investment decision on misleading information that had been published by that company. So there's a particular statutory regime under which companies can be liable in respect of misleading information that they've published to the market. So, for example, periodic financial reports, that kind of thing. And the particular provisions are in the Financial Services and Markets Act 2000, particularly Section 90A of FISMA, if you want to look it up. So, to establish a claim under those provisions, an investor has to show that the company's published information contained a misstatement that a director knew was untrue or misleading, or that there was an omission in the published information that a director knew would result in the dishonest concealment of a material fact, or that there was dishonest delay by a director in providing information. So that you kind of got three limbs to the claim there. So it's either a misstatement, an omission, or a dishonest delay. Now, for misstatement and omission claims, but not for the third category about dishonest delay, the investor has to prove that they relied on the company's published information when deciding what to do with their shares. And the required standard of reliance can be very difficult to prove. And this latest case, which is Allianz and Barclays, appears really to have raised that bar to an even higher level than we already thought. So the case involved a shareholder class action against Barclays. The claimants, who were all institutional investors, alleged that Barclays had made false and misleading statements in published information, or they had omitted to include certain matters within that published information. Now, in the class action, the claimants had been divided up into three categories based on the different ways in which they'd relied on the published information. And a significant proportion of the claimants, who were known as the Category C claimants, were index or tracker funds that hadn't actively read or considered any of the published information. Instead, these passive investors based their claim on what's known as price or market reliance, where the Barclays share price would be assumed to reflect the contents of all published information. So that what that meant was that in making investment decisions based on price, the investors were still placing reliance on the accuracy of the published information. Now, Barclays applied to strike out the claims of the Category C claimants on the basis that price or market reliance did not meet the statutory requirement for reliance in relation to these claims. So when it came before the court, well, the court agreed with Barclays, finding that the claims of the Category C investors had no real prospect of success. The judge decided that Parliament's intention here was for reliance to mean the same as it does in the common law tort of deceit. So, in his view, the test for reliance, as it applies to express representations, requires the claimant to prove that they read or heard the representation, that they understood it in the sense which they allege was false, and that it caused them to act in a way which caused them loss. And what that meant was that the requirement for reliance could not be satisfied where the claimant hadn't read or considered the published information. And because the Category C investors hadn't read or considered the relevant documents, their claim failed. So, subject to any appeal, that decision could significantly reduce the ability of passive investors, which make up about 30% of UK markets, to seek redress for loss resulting from misleading publications. If that price or market reliance doesn't meet the relevant statutory requirement for reliance, then investors will need to prove that the published information was factored into their investment decisions in some other way. An interesting question, I think, is whether artificial intelligence processes, for example, would satisfy the test, or whether actually what the court's saying is you need the exercise of some human discretion here. If passive investors aren't able to show the necessary level of reliance due to the very nature of their trading practices, then they may well be left without a remedy when a company in which they've invested misleads the market. So a bit of a surprising outcome, that one, I think, and one which potentially could have some quite serious ramifications for investor protection in the UK, given the level of investors who invest in those kind of tracker funds. So that's it for 2024. I hope you all enjoy the festive season, and we'll be back with more updates in the new year. But bye for now. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.